Our next and final speaker for the morning is David Lepofsky, and he's going to address the expanding duty of accommodation under the heading of keeping up with the duty to accommodate. David?
I felt, in light of the last panel, that perhaps the appropriate way to begin now is to suggest that Jeff and Lynn should be sent outside for drug testing, since obviously they're going to find that being in the line of my fire is a high-risk activity. I am going to try to bring a little light into the gloom in the area of the duty to accommodate. As this is usual as a public servant, I'm supposed to say that I'm not speaking on behalf of anybody but myself, and certainly not on behalf of my employers. Let me begin in addressing the duty to accommodate by offering a paraphrase, if not a quote, from some lawyer, dare I say it, a management lawyer, forgive me, Jeff, to a management lawyer who was speaking to a bunch of personnel people at a conference a couple of years ago to discuss the duty to accommodate. I got to bat cleanup, and after this quote I saw that there was a lot of cleanup to bat. This person led off a description for the personnel managers in the audience of the duty to accommodate to this effect. The duty to accommodate is one of the most difficult concepts in employment law. My response was either employment law is very easy, or the person who was speaking must find all law very difficult. I find in my work in the area of accommodation, both writing, teaching, litigating, and dealing with individual government of Ontario employees who are having difficulty getting employment, getting accommodation, that those who have little or no knowledge about disability but lots of knowledge about employment law find this a very difficult subject. Those, like people with disabilities who themselves know a lot about disabilities and no knowledge about employment law, tend to find it's not so difficult a subject at all. In fact, it's pretty straightforward. One of the barriers we face in getting accommodated is the false perception that somehow the duty to accommodate is this ugly bugaboo ogre, as Lynn said before, designed or driven to the point of near bankruptcy, and somehow is something which is hard to do, problematic to do, and Lord, why do we have to do it anyway? Let me try to debunk that mythology and bring, if you will, a practical perception on it. In doing that, I intend to briefly identify what the duty is, focusing particularly on the needs of persons with disabilities, why it's there. I intend to then address a couple of the defenses that are most commonly put forward to oppose accommodation claims. And finally, I'd like to conclude with a couple of, if you will, sort of cutting-edge developments or new revelations in this area. What is the duty to accommodate? Well, particularly in the area of disability, it is the duty to facilitate people with disabilities or other Human Rights Code designated groups in being able to fully participate in the workplace on full and equal terms. In the case of people with disabilities, it tends to include any of 3 or 4 kinds of accommodations or combinations of them. It may involve providing them with accessible premises with exits and entrances that they can get into, washrooms they can use, and escalations like steps that they can get up through elevators and ramps or elevating devices. Second, it can include the provision of adaptive technology. Sighted people use print computers. Blind people may use a computer with a braille printer or a speech synthesizer plugged into it. Both use the same computers to access the information. The third possible accommodation might be something in the nature of provision of support services, whether it includes, again, for visually impaired people, a human being who can provide reading services, reading text materials out loud, some supportive note-taking, that kind of thing. A fourth kind of accommodation would be job restructuring, If the job includes some duties that the person with a disability cannot do even with reasonable accommodation, it may involve reorganizing jobs, shifting duties to other folks that they can't do, that the other folks can do, and shifting to the person with a disability more duties that they can do. Something foreign to our workplace, it's called efficiency. And perhaps the final kind of accommodation might be modified work hours. If a person, for example, needs dialysis and has to go to secure treatment, they may have to go to work at different times and be away at different times. If a person has a fatiguing condition like multiple sclerosis can provide, it may involve organizing part-time work rather than full-time work. All of these things share in common essentially two themes. First, they are there to enable the person with a disability to fully participate in the workplace, to liberate from them all of their abilities, to draw from them all their talents, and therefore to secure the maximum efficiency in the workplace. And the second theme that the duty to accommodate secures, or promotes, or advances, is to respond to the fact that our world is occupied by 85% temporarily able-bodied people and 15% people with disabilities, but is designed predominantly as if that 15% people with disabilities do not exist. That is to say, our workplaces, our law firms, our transit facilities, our schools, and the like, our telecommunications technologies, and all those are designed on the fallacious assumption that they are only of use or to be used by people with 2 arms that work, 2 legs that work, 2 eyes and ears that work, cognitive functions at the statistical average, and so on. Of course, none of us know anybody that meets all of that description, but that's the only people who are supposed to use all of our society's opportunities. The essence of the duty to accommodate is the removal of barriers that have been created so that people with disabilities can fully participate, to eradicate from our world, or at least to diminish in our world, these litany of constructs which were built on this bogus assumption that people with disabilities either don't exist or don't want to or can't or shouldn't participate in the workplace or elsewhere. Well, if that's what the duty to accommodate is, and that's why it's there, then let me briefly turn to a couple of the arguments that are advanced under the rubric of undue hardship in order to justify failures to accommodate. May I begin by indicating that were I in the position of advising an employer or a trade union on whether they should accommodate a person and to what extent they should, rather than waving bugaboos about bankruptcy or the threat to the collective agreement and the end to collective bargaining as we know it, which sometimes has happened on the part of either union leaders or managers who don't want to do anything other than the way we always did it, because after all, if we did it all this time, it must be right? That's called efficiency too. Rather, I would be inclined to advise, much as I did when I was counsel with the Constitutional Law Division in the Ontario government, and I was advising a ministry on proposed legislation which clearly had the tendency to impinge on a charter right. I would tell them that yes, you've got Charter Section 1 as a possible defense. Yes, you can advance a case of reasonable limits, but I encourage you, at the point of giving you advice, to legislate as if you don't have Section 1 available, to do the absolute most you can to accommodate the rights, in my case the charter rights, in your case the human rights of employees, because it's better to accommodate at low cost than to litigate at high legal cost. And in fact, those who have tended to refuse to accommodate and to litigate have probably spent multiples of 10 times more on their lawyers than they ever would have spent on accommodation. Within that rubric, let me turn to a couple of the defenses that are advanced. One defense that is available to a failure when there is a refusal or a failure to accommodate is the argument of cost. It would cost us too much to accommodate. Cost arguments should be advanced at one's peril for the following reasons. Firstly, the burden is on the respondent to prove that it costs too much to the point of undue hardship. Second, the Supreme Court of Canada has said that de minimis costs provide no defense. It's got to be a serious cost burden. How serious is open to debate, but it's probably better to pay it than litigate it. It'll cost you a lot more. Third, cost must be measured on the assumption that you are engaging in the least cost accommodation. That is to say, it is inappropriate for an employer to contemplate the most costly, gold-plated, blue-chip accommodation that probably nobody wants or needs and say, well, that costs too much, so I'm going to do nothing. Fourth, it is bogus to assess costs out of context. Employers accommodate able-bodied employees all the time. How many lawyers and managers have cellular phones provided by their place of employment? How many of them really need them? How many of them got by without them before 2 or 3 years ago? Okay? But providing a cellular phone to a senior partner is a God-given right. But providing a Braille typewriter to a blind person is a special accommodation that those people seem to insist on, even to the point of bankruptcy. How can we survive? Okay? Next, cost must be assessed in light of other priorities. It is fallacious to suggest that costs must be assessed as if every last dollar has been spent and accommodation, fundamental human rights, is the lowest priority. Even if your budget is already set, it is open to the employer to take a critical look at whether they might do a little streamlining. My favorite inquiry, when one is inquiring into an employer who refuses to accommodate on grounds of costs, we can't afford that, is to ask how much they spent last year on wine and cheese, or perhaps before this year, Blue Jays tickets. Nobody spends anything on Blue Jays tickets this year, of course. At least they shouldn't. But in any event, it may be that there are other expenditures that they could forego that are lower priority, and the fact of their invoking cost as a defense is really just a proxy for deep-rooted, unarticulated, and even unrecognized prejudice. Finally, costs should be assessed in light of benefit. In other words, if you spend the money, you may get advantages out of it. My employer has bought for me a relatively expensive document scanner. I put a hard copy document in it, it scans it into the computer, and the computer can then read it to me. That is a cost. It is a cost that you do not have to spend on sighted lawyers. So one might say, well, so where's the efficiency? Well, the efficiency is that no month goes by when at least one lawyer or secretary hasn't waltzed into my office and said, my disk has crashed, I have to get this factum retyped, can you scan it for me? And within 2 minutes, I've saved them about 2 days of secretarial work. That's called a contribution to efficiency, and that should be assessed in light of the expenditure made. So cost can be advanced, but it should be advanced at your peril, having regard to the fact that there are lots of offsetting considerations. Other defenses available may include threats to health and safety. They've got to be real and proven, not speculative, and threats to the collective agreement and collective bargaining rights. The collective agreement is not an absolute defense, though it can be taken into account, and my answer in the collective agreement front may well be waiting until we get to questions. Let me turn to some closing observations that you may find of some assistance. First, at least in the even though most of the litigation at the Supreme Court and Appeal Court level in the duty to accommodate area has related to the need on the basis of religion not to work Friday night or Saturday, the fact of the matter is that most of the accommodation business out there is probably in the disability area, because the right to be accommodated, or the duty to accommodate, is core, not peripheral, but core to the guarantee of equality to persons with disabilities, because our world is so riddled full of irrational and unnecessary barriers confronting us. Secondly, it is traditional to talk about the duty to accommodate in relation to employment, and it is very important there, but there is a new area where the duty to accommodate equally applies, and it is somewhat uncharted so far, and that is the duty to accommodate in the area of provision of goods, services, facilities. There's a duty to accommodate in all of those contexts. When I wanted to buy a VCR a couple of years ago, I contacted Sony to see whether there was any way to interface it with a computer so that all that whiz-bang picture junk you get on the screen might be articulated so a blind person could program it. Of course, Sony has spent gazillions of dollars making VCRs totally usable by anyone, right? But the answer I got from their head office is, why would a blind person want a VCR? My answer was, to record television programs. Isn't that what everybody does? But the assumption is that goods are going to be made with all the greatest bells and whistles for the able-bodied, but people with disabilities aren't going to use them. Same with public transit, same with services, and so on. That's got to change. The duty to accommodate clearly applies there. My second last concluding observation is that there is a tendency to think about the duty to accommodate in relation to the removing of old barriers that exist out there already. Subways that were built 20 years ago, buildings that were built 30 years ago, and so on. And the fact is that the duty to accommodate does address those, but it has a new component as well, and that is to prevent the creation of new barriers. Yes, there are many new barriers being created now, even as we speak, in employment, in collective agreements, in the devising of public facilities, in housing, in goods, and in services. And the duty to accommodate not only applies there, but I would propose that it applies there with even greater force. For once employers, service providers, unions, and the like know, as they now should, that they have this duty, then they are able to prevent barriers from being created a priori much more economically than to retrofit old buildings, old goods, old agreements, and the like. And therefore, their duty to accommodate in relation to future barriers is, I would contend, a much more onerous one, because the ease to accommodate there is so much easier. Put another way, the old excuses won't last much longer for failing to accommodate in relation to future barriers. My final observation is not a legal one, but is a practical one. What does the duty to accommodate, how does it operate on the front lines? Not in the grievance arbitration or at the Human Rights Board or at the Supreme Court of Canada, but in the practical level. I acquired, pardon the visual reference, a real eye-opener about a year ago when I got involved in a Ontario Public Service advisory group of government employees with disabilities that advises the Ontario government on employment equity and human rights considerations. I thought the Ontario government was pretty much had the problem of the duty to accommodate in hand. We had a strong human rights code. We had the Human Rights Commission promulgating guidelines that gave it strong teeth. It got employers upset, so it must be good. We had the Ontario government passing an internal accommodation policy and communicating it to all managers, which was strong. And in addition to the Human Rights Code, we had the Ontario government promulgating an internal enforcement process, an internal complaints process that allowed for quicker relief than the Human Rights Commission could ever give. And finally, the Management Board Secretariat had appropriated a large sum of money to set up a job accommodation fund to fund accommodations so that they wouldn't cost local divisions and ministries anything. And the fund is quite accessible, it's quite unbureaucratic, and quite generous, I've found. So I figured everything was quite cool. Then I went to my first meeting of this advisory group and found out that there is widespread problems facing people with disabilities in getting accommodations in the Ontario Public Service. What's going wrong? Well, let me tell you what's going wrong. Several things. Firstly, managers at the front lines still do not know and understand what their obligations are. And if they don't know and understand it in the government, Lord knows what the level of knowledge would be in the private sector, where they don't have all this infrastructure I've described. Second, employees face harassment at the hands of their fellow employees and their employers, even if accommodations can be funded. Why should you get special treatment? Why should you get a better computer? And so on. Third, The process of securing accommodation has become somewhat bureaucratized. And finally, nobody has yet put their finger on the nub of this issue, and that is that the employer not only has a duty to accommodate, which they do, but they have a duty to provide a welcoming environment within which an employee with a disability can seek and obtain accommodation. People with disabilities often don't want to ask for it, often may feel intimidated about asking for it, and may be made to feel uncomfortable once they have asked for it. And therefore, the obligation is not only to respond to the request, but I would say to provide a welcoming environment within which the request can be brought forward. Therefore, there's a lot of work that's got to be done, not only at the legal level, but it's sitting down with employers and unions to have them understand that accommodation contributes to efficiency, that it's easy to do, that if it's the most difficult part of employment law, most employment lawyers should probably take up a second area of practice, and that in the end, the accommodation of people with disabilities serves efficiency and contributes positively to everybody. Thank you very much.
Thank you, David. And as before, we're going to now discuss a series of questions, and I asked David to join the panel in responding to them. David, in your paper, you assert, and I really urge you all to read the paper carefully, that accommodation is highly individualistic as opposed to a collective need, that it's only fulfilled over time by trial and error, and that it's ongoing. This poses a real challenge to those who are subject to the duty, and that is, how is an employer or union or both to know when the duty to accommodate has been fulfilled?
The answer, just get this thing working. The answer is this: it is fulfilled when the employee is able to have their needs met so that they can fully participate on equal terms in the workplace. It is only, no one has suggested, including myself, that the duty includes providing the best, the juiciest accommodation alive. Much as any one of us might play around with whether we want to dictate by dictaphone or get a secretary to take shorthand or type into a computer until we arrive at the right system. It may be, if the first accommodation is tried and fails, that you have to engage in trial and error. Trial and error is only needed to the extent that it is needed to find the right fix. It's individualistic because everybody has different needs. Two people with the exact same visual acuity may have very different ways of doing things to accommodate their visual impairment. Some accommodations may be, if you will, broad brush and adequate. That is to say, if you've got stairs and you put in a ramp, that may well attend to your at least one of your physical barriers, and you don't have to put in a new ramp every time a new person in a wheelchair comes in. But it's important to realize that these barriers tend to be put in without regard to individual needs, so you tend to have to look at individual needs to fix the problem.
Thank you. And do you have anything to comment on at what point is it sufficient to say, now this is enough?
I want to go back to something. Is this working? Yeah. I want to go back to something David said, actually, that
Please.
kind of answers the question,
Please.
but addresses this other point as well. David talked about not needing the Cadillac model of accommodation. If you look at the undue hardship guidelines from the Ontario Human Rights Commission, you'll see that there is a hierarchy of accommodations set up, so that the way you approach the analysis is to look at the variety of accommodations that might be available, and then you must provide the accommodation which best fulfills the needs in a manner that's keeping with dignity, provided that accommodation does not constitute an undue hardship. So if you've got 4 options, one of which is coming in the back entry with the garbage, and one of which is a full elevator service that costs $150,000, and there are 2 in-between things, you must start with the best. That costs $150,000. Is that an undue hardship? If it is not, according to the undue hardship guidelines, then that is the one you must do. If it is an undue hardship, then you move to the next most dignified manner of accommodation, and so on. There's been a recent case from a board of inquiry dealing with this issue, which gives, I think, a good reason to doubt whether or not the undue hardship guidelines on this will hold the day. The case is called, I think it's Barber and Sears Canada. It's a Board of Inquiry in Ontario. It just came out within the past month or so. In that case, there was a Sears store in a mall, and it was not accessible to the second floor. You could get into the ground floor, but not the top floor. The mall, when originally constructed, was to have an elevator going to the second floor, and it was never put in. The store itself didn't have an elevator to the second floor that was a passenger elevator. It had a freight elevator, which was quite unsightly and awful and came in through a horrible entrance and so on. It had to be operated by somebody else, and it really was quite a disgusting thing. So a complaint was filed by a customer. Between the time when the complaint was filed and the hearing proceeded, Sears Canada ran out and fixed up their elevator. Now, it wasn't a full passenger elevator still, but they made it pretty. They made the lobby that it came into now full, which used to be full of boxes and debris and garbage. They cleaned that all up, made it look like an actual reception area. They made sure that there were people available to come and help operate that elevator very quickly. There was a very short turnaround time and so on. Now, this is not ideal. The ideal would be a regular passenger elevator that an individual could operate by themselves, not have to summon someone to come and convey them. But what the difference in cost was quite significant. But there was no attempt really to show that putting in a proper passenger elevator at Sears would bankrupt or come anywhere close to bankrupting Sears Canada. The Board of Inquiry, however, found that the accommodation that had been provided was adequate, that it served the need, and that at least some of the people who testified did not find it to be undignified, that it in fact was not as undignified as the previous means of access to the building, and it was in fact dignified, although not the most dignified and appropriate means. And this, they found, satisfied the duty to accommodate. Now, I have some real difficulties with it, but I would not be surprised to see it being applied more and more.
Jeff, I wanted to vary that question somewhat in the context of the union role. Whether you could discuss some circumstances when parties other than the employer must participate in fulfillment of the duty to accommodate.
Right, well, what I have to say bears largely, I guess, upon the Renault case, which is in your materials, and which I urge you, if you're going to read any one thing on this subject, to read from start to finish, because it is the final word on the subject of the duty to accommodate. And on the question that has just been asked about what lengths an employer must go to accommodate, I would refer you to the final page or two of that decision, in which the Justice Sapinka said this: the employer is in the best position to determine how the complainant can be accommodated without undue interference in the operation of the employer's business. When an employer has initiated a proposal that is reasonable, the complainant has a duty to facilitate the implementation of the proposal. And then he goes on to say the complainant cannot expect a perfect solution. So there are limits to this, and from the point of view of dealing with the complainant, that is the way the Supreme Court defines the obligation. Now, when it comes to the union, and that case involved the question of the union's responsibility, the Supreme Court distinguished between two situations. One was where the discrimination, let us say a work schedule that required people to work on the Sabbath, was the result of a clause in the collective agreement, in which case the union would be jointly liable with the employer. And another situation where there was a neutral work rule that the union was not a co-author of, in which case the union had a duty not to block any attempts by the employer to accommodate the employees. Now, what does that translate into? It translates into this: the employer is the one who initially has the obligation to accommodate. The union has a responsibility not to participate in discrimination and not to block attempts at accommodation. It also, however, has the right to ensure that the collective agreement does not suffer any substantial impairment, and particularly that the rights of other employees are not affected. The Supreme Court said you don't have to substitute discrimination against one group in order to mitigate it against another. So what's going to happen in the workplace? Well, I suspect this. When an employee asks for accommodation, the employer is going to try to figure out what is the cheapest method. Probably will figure out the cheapest method is to ask the union to modify the collective agreement and to ask other employees to forego their rights and their entitlements, such as, for example, shift preference, as in the Renault case. The union is going to turn around and say no. Now, what should the union do in that case? Because the Supreme Court has said that the union is entitled to say that any non-trivial interference with rights of others under the collective agreement constitutes undue hardship. The union can say it's undue hardship to impair the rights of others. So what should the union do? The union should, and they've all been advised to, come up with ideas for the employer to accommodate the employee without disrupting the collective agreement. So there's going to be that tug of war where the employer tries to put the burden on the union and the cost on the union, and the union is going to try to put it back on the employer where it should be. So my advice to unions and those representing unions is to come up with endless ideas as to how to accommodate the employee. And surely among them there's going to be one that's reasonable and hopefully one that the employee will find acceptable. Frankly, on a personal level, I'm continually surprised at how little there is that is done by way of accommodation. I'm continually observing how impossible it is to access buildings and rooms and floors for anybody who isn't a fully abled person. So I think there's a huge way to go, and there are lots of things that employers can do.
Jeff, I've had some indications that there's some requests here to make some reply, and I'm going to start just coming right back down the row with Anne first, and then David.
It's more an itching to retaliate.
Why don't we start with telling them what the decision said?
Yes, I was going to say Renault wasn't quite so clear as I recall, but
No, it wasn't actually. But Jeff has always been confused about this case, taking the opposite side that I took. Not totally opposite. When reading Renault, beware. It is dealing with legislation which is quite different from the Ontario legislation. It is true in that case there was some reference to the collective agreement and the infringement of rights of others being in some way relevant. That doesn't approach, I don't think, what Jeff is suggesting, that you have to do everything else first before you can breach the collective agreement. In fact, the case said quite clearly that collective agreements are contracts, and contracts are overridden by human rights. So a collective agreement takes no special priority. It is not the magic of it being in a collective agreement that constitutes an undue hardship. It is that you try to find the best accommodation that doesn't constitute undue hardship. Interference with the rights of others, whether enshrined in a collective agreement or not, is something to be taken into account in some legislation, not in Ontario. In the federal legislation and in other provincial legislation, such as BC, which was at issue in Renault, it's a more open process. In Ontario, the only relevant considerations are health and safety and cost. So bear that in mind. With respect to the issue of cost, it is true, I think, that we do not have a handle on it yet. We don't know how far one must go. What constitutes an undue hardship in the area of cost? How extreme does it have to be? There will be a case coming out soon which may clarify it in Ontario, the Quinnell case. It's under reserve still. But when David was speaking, I had a little giggle about the Quinnell case, because that's a situation where the respondent spent something like $75,000 trying to prove that a $10,000 ramp would be an undue hardship. and then sought legal costs of that amount in compensation. It was also a case in which Blue Jays tickets were involved. I think they were in excess also of the amount spent on the that would have been spent on the ramp.
Right.
Season's tickets.
Well,
but let me
say-
just finish that
yes.
point on the undue hardship and whether it is nailed down. It is not. I differ with what David said, that this is an easy concept. I think the practicalities in the workplace are not that difficult, but actually giving advice to an employer who doesn't want to do the accommodation is not that easy, because we don't know how expensive is too expensive. We don't know how much risk you must take. Is there a difference in the risk to other employees, a difference in the risk to the public, a difference to the risk to the employee that actually has the disability, which they agree to take on themselves? All of that stuff is not established.
Right. David, we're fast approaching the time for your questions, and I promise you to do that.
The advice before I get to the world in which Jeff lives is that I would give a client if I or Ann were in the unlikely position of advising employers is a very simple piece of advice. Rather than debating over the esoteric question of where the line is on undue hardship, do what you can.
Exactly.
You've always got the best defense. If you did everything you could, then you can always stand up and say, I couldn't do any more. When people get in the box and say, I did what I could, and then either Ann or I, depending on who's the client and who's the counselor, is cross-examining them and can present them with an afternoon's worth of very practical suggestions that they never thought of and never tried, the cross-examination is like pelting eggs. It is very easy to do. It's better to get that advice up front. As for the world of the trade unions, shockingly, I'm more inclined to the view of it that Ann articulated than Jeff. What I would say is just a few very brief points. First, the problem, as I see it in the trade union area, is very much like the problem in the management area. If they want to accommodate, then 99.9 times out of 100, they will find a way to do it. And whether it ends up being number 1 or number 2 or number 3 on the hit parade of accommodations ultimately may not matter in the practical world, though it may in litigation. But you will avoid litigation by just doing it. When they don't want to do it, they can 9 times out of 10 either point to or invent some collective agreement or collective bargaining concern. When the complainant gets tossed into the melee of employer distrust of union and union distrust of employer, it is invariably the complainant who loses. Moreover, the ideology that has prevailed on, I think, many shop floors, though Jeff can speak more than I to this, is the view that to treat anybody differently than everybody else is somehow contrary to collective agreement values. That may be one of the general philosophies of collective agreements, but it is total contradiction of the essence of the duty to accommodate, which is different treatment. With respect to the duty on unions to accommodate, as a practical matter, I subscribe to Jeff's view that what the union should do, if they got their nose out of joint on one particular accommodation, is to come up with lots of other alternatives, because ultimately, if they fix the problem, they avoid litigation. However, last point, I don't share the view that somehow the collective agreement, if it creates rights, is therefore sacrosanct, particularly where the interference is non-trivial. The result in Renault, firstly, you can't contract out the Human Rights Code much as they may want to, and secondly, what Jeff said as to his interpretation of the reading of the case must be read in light of the outcome of the case. In Renault, Mr. Renault wanted to work Friday days or Thursday days instead of Friday nights. He couldn't because he didn't have seniority. So to allow him to get what he wanted would be to violate the seniority clause and therefore to contravene the very principle that Jeff says is so deep-rooted in this decision and you must all follow. The court found for the complainant and against the union by saying you could have tried talking to other workers about swapping shifts. So that there was, even though an accommodation might violate the collective agreement terms in an area of fundamental collective agreement rights, according to some, seniority, the union was nevertheless held liable. So don't just read the text. Look at the result.
Now, since this isn't litigation, I'm going to have to say, Jeff, we can't have reply. Right.
And
No, you didn't.
but no, but Lynn, I just want to,
You were an
I'll be
intervener.
very brief on this, okay? I'll be very,
You're an intervener. You only have
just
15 minutes.
just a minute.
All right, 5 seconds, Jeff.
Okay, first of
Time's
all,
up.
on the issue of who's accurately reporting this case, I suggest you just read page 992, okay? Because I stand by every word of what I said, it says. Number two is, unions have had a lot to learn in this area, and I think they've come a long way. Unions want to see that employees are accommodated. They represent the disabled too, and they very much want to see as much done as possible. So, and finally, in number three, in terms of the Renault case and how it worked out, yes, seniority was interfered with. Why? Because no volunteers had been canvassed. The employees hadn't been canvassed as to whether they would volunteer to take over this person's shift. So for that reason, they weren't entitled to rely upon their seniority rights. But if they'd done that, then I think the Supreme Court of Canada would have said, that's a non-trivial substantial interference, and the union doesn't have to do it. Because these people wait for 10 years to get to a point where they can exercise their shift preference to a day shift. And when you get a new employee coming in and saying, for religious reasons, I want the day shift, that is a real problem.
Okay, that leads us very much into the next. I almost got that one, didn't I? It gets us into the last point, and I'm
Where's
actually
the
going to
off switch on her mic?
start with a comment here. And I think this is a very important point to be aware of, which is, are there any circumstances where a duty to accommodate arises where no request has been made by an employee, which is a variation on a question that was asked in an earlier panel. And the reason that I think it's important to draw to your attention are twofold. One is Bill 79 is coming, the Employment Equity Act. And in Bill 79, there are statutory duties to accommodate. So just to provide you with the scenario, the duty arises upon self-identification by the employee as being a member of a designated group. And I think one of the points I want to draw to your attention is that the duty to accommodate is very likely to expand in the coming years. Because David is entirely correct, and Anne's echoed those as well, and which is that the focus has been, and for good reason, it is the core of being a disabled worker, is accommodation. But in many ways, it is also the core of being a working parent or other persons who require accommodation, who need to have the removal of barriers that allow them to participate most fully in the workplace. And Bill 79 imposes a statutory duty to look at what accommodation is needed. And one of the questions that has been raised in the context of addressing the impact of Bill 79 is whether it will now be incumbent on an employee to request accommodation in order to fulfill that duty. And on the understanding that everyone will try to answer this in about 40 seconds or less, I'm going to start with David, and then we'll go to your questions.
Let me begin by answering Jeff.
No, please don't. Please don't.
But moving right along, had I had that opportunity, the duty to accommodate people with disabilities under the Human Rights Code tends to be triggered by a request, because the barrier may have been created unintentionally, and therefore it is the request by the worker for assistance that would give rise to it. However, if I am right in my remarks earlier, that there is the duty includes a duty to prevent the creation of new barriers, then within reason, the duty involves, for example, if a business is going to buy or acquire or build new premises, building access in now, because no one in this country should be oblivious anymore to those access needs. And it is, I think, it would be bogus for Employers' Council to say, well, that in 1994 we built a new building, we willfully built it, riddled with barriers, and then up comes this person in a wheelchair, and oh, we're sorry, it would cost too much to retrofit.
Anne?
What was the question?
The question is, are there circumstances where a duty to accommodate arises where no request has been made by the employee?
Yeah, I didn't think David answered it.
I did so. Answer Jeff.
These are old debaters from way back, as you
There
can
are
hear.
there are a number of cases that indicate that there is some obligation on the employee where they're claiming a legal right to be accommodated, to at least communicate either what the disability is or what the accommodation required is. This does not mean that the employee has to now be the expert on making your premises accessible, or the technocrat who knows everything about the computer technology that you must provide. But there is some minimal expectation that the employee will at least communicate to the employer, I'm having trouble doing X or Y because of a disability, I need some accommodation. So there is that sort of level that's been established for quite some time. I'm finding out there, though, that employers are increasingly saying, tell me exactly precisely what it is that you want. Get me the specs, get me the costing of it. I want experts, I want this, I want that, and putting all of that burden on the employee where it clearly, in my view, does not belong.
In fact, if anything, that might be another barrier. Jeff, can you just wrap up on this point? We'll go to the floor.
Yeah, I can wrap up very quickly, Lynn, because I go back to what the Supreme Court said on this very issue. It said that in determining whether the duty of accommodation has been fulfilled, the conduct of the complainant must be considered. This does not mean that in addition to bringing to the attention of the employer the facts relating to discrimination, the complainant has a duty to originate a solution. The employer is in the best position to determine that. Now, so the employee has the duty to bring it to the employer's attention, and the employer has the duty to originate solutions, and the employee can make suggestions. That's the way it should work. But on the other part of your question, which I didn't think was answered, and I was kind of interested in what the answer would be, is when the Employment Equity Act is finally proclaimed, what impact is this going to have on the duty to accommodate? Are there going to have to be proactive measures taken? And how does that compare with the Americans with Disabilities Act? And I thought that, David, you were going to tell us the answer to that.
Probably in 25 seconds, right? Let me now answer, Jeff, but on this one. The Bill 79 includes a requirement to identify, to undertake, for businesses covered by it, an employment systems review in an effort to identify and remove barriers, not just barriers that would be caught by the duty to accommodate, but barriers that may be festering and might eventually become human rights violations. To essentially build into business deliberations pre-thinking about these issues. As a practical matter, for example, and pursuant to that philosophy, the group with which I'm affiliated in the Ontario government is asking the Ontario government to adopt a policy that before it buys any new technologies, they're out there buying computers all the time and software, that they put in the request for proposals a requirement that bidders confirm that their technologies will be disability accessible and barrier-free. So that kind of practice, which will lead to efficiency and barrier removal, may not, on traditional reading of the code, be code required, though it may be, but it certainly is related to the Bill 79 employment equity deliberation of preventing problems before they happen. I'm not going to get into the Americans with Disabilities Act because that requires a whole other panel.
Okay, I just want to say very briefly, the simple answer is you won't know unless you consult. That's the simple answer about what is the need to accommodate, and that is built into the Employment Equity Act. Rather than taking any more of your time, are there any questions? We'll start at this side of the room.
My question is, I'm also employed at the Department of Justice in Ottawa. My question is the interface between this problem and the fact that in the public sphere, this is also charter to a great extent, and how the interaction, I guess two questions, what's the interaction between Section 1 of the Charter and the duty to accommodate the public sector, and the second is how the unions propose or how to deal with the whole issue of charter rights and the collective bargaining.
Okay. David, would you please start with that?
On the first point, I would argue that government employees, such as yourself and myself, would have a duty to accommodate not only under the applicable Human Rights Code, but under the Charter, but it would make sense to litigate it under the Human Rights Code largely because it'll cost you less. And as for how unions deal with it, I think whether you call it charter rights or human rights, I think the best practice is for employers and unions when they sit down to bargain collective agreements to seek in advance to identify human rights barriers and to when they're going to draw up a collective agreement, and this is important to what Jeff said earlier, to use more aggressively the anti-discrimination clauses in their collective agreements. If Mr. Renault's collective agreement had had an no discrimination because of religion clause, then in my view he could have been accommodated notwithstanding the seniority rights of others without contravening the collective agreement, because the collective agreement's own non-discrimination clause, its own human rights clause, being fundamental, would trump and override the seniority clause, and therefore there would be no seniority rights to violate.
But if I could just comment on that, those of you who are aware of Bill 79 know that seniority has been exempted as a barrier. So that would not be the case under employment equity. There's been a specific exemption to say that, in effect, seniority will stand inviolate. It cannot be touched when assessing whether seniority operates as a barrier to these kinds of matters.
In terms of employment equity, except where there's been an adverse finding by a Human Rights Board, but it is still open to, and believe me, we are using Human Rights Code analysis to attack or question the application of seniority.
And query whether that clause is constitutional.
Indeed.
Absolutely.
Okay.
I'd like to address the Section 1 argument that you raised, not just with respect to federal employees, but with respect to how you interpret the Canadian Human Rights Act as it applies not just to public sector, but private sector covered by the Federal Act. The Simpson, Sears, and O'Malley decision from way back when, which was the first adverse impact discrimination case, really, that solidified that law, dealt with a statute at the time, the Ontario statute, which simply said, "Thou shalt not discriminate," much as Section 15 of the Charter now says everybody is free. There shall be no discrimination. In the context of that, the court read in a duty to accommodate, limited only by the undue hardship standard. I therefore think it is very persuasive, using that case, particularly in light of Andrews and how you use human rights cases now to analyze the Charter, that when we look at the reasonable limit to Section 15, that reasonable limit is likely to only go to the undue hardship standard, that's likely the standard to be applied when you look at Simpson, Sears, and O'Malley and the other cases that followed it.
What I'd like to do is just take one more question at this time, and for those of you who want to stay, can the panel stay for a few more minutes? But those of you who have to go, of course, you can. And since part of my request is to make sure that you do your evaluations, I'll make that now. Could we have your question, please? Shall I answer that?
I can do part of it.
Well, I had thought my recollection of the Employment Equity Act is it said the negotiations were to take place separately from others, from the main set of negotiations, so that it wasn't to be encumbered with the overall bargaining.
I'm not right up on the clauses, so that I can't really answer that at the level of the legislation, but I can say this from the perspective of the work that I'm doing with this advisory group that I'm involved in. I have taken the position that if an employee has an accommodation need under the Human Rights Code, the employer or the union can't say, well, we've got to deal with that at the collective bargaining table, or we've got to deal with that at the employment equity table, or we got to do that at some other table, we don't know what the table is, or what shape it is, or whatever. They got to accommodate. And if there is no collective agreement barrier, then they can get on with it. If there is a collective agreement barrier, then they've got to decide whether Renault provides them an excuse, or whether they could reach a collateral agreement to deal with the individual accommodation needs. That's part of the individualistic thing. They've got to resolve it, and they've got to resolve it now, not wait till the protracted employment equity process or collective bargaining process exhausts itself.
I just want to comment on that. That's a really important distinction here, is that it's the question of collective versus individualistic rights, in part. That is part of the point that's been made there, is that collective bargaining is going to be separate from employment equity plans for a whole variety of reasons, not least of which is the statutory mechanism that's contemplated to create an employment equity plan or plans. But the bottom line is there's going to be a huge amount of overlap between the two. And the tribunal, the Employment Equity Tribunal, is told not to alter the collective agreement unless it can't find any other way to come up with a remedy. So that what that contemplates is the workplace parties working it out for themselves to as large as they can, as to the degree they can, within the context of these statutory obligations to consult and probably negotiate is a better term, although the Act doesn't use that, the bill doesn't use that, on each of the steps required to achieve employment equity. But that never will take away that collective decision, whether it's in a collective agreement or an employment equity plan, will never take away from the individual rights that continue to exist under human rights codes. And I think people sometimes lose sight of that. Now, that concludes the formal part of our program. I wanted to thank you very much for your participation and attendance. And on behalf of the Law Society, I urge you one more time to complete your evaluation. They're very important, very helpful to future planning. And I hope that we'll see you again at a program soon. Thank you very much.